And then we have Mark Taylor. Due diligence, a compliance standard for reasonable, responsible European business. Thanks.
Thank you. That's just the institute where I work. Yeah. And thanks to Beata for the invitation, and to her colleagues, to Beata and her colleagues for the organizing the conference. And to all of you who've been working on the project, because when I found out about the project, about a little more than a year ago, I became very excited because I felt that the questions, having worked for a number of years in the area of business and human rights, I felt the questions that you were asking were, how shall I put it, refreshingly radical and critical. In a field that is dominated by a CSR ethic going back 2 decades, that is neither of those things. And also because I've been involved in over the past few years in 2 different comparative law projects in the area of human rights and international criminal law. And it's the most recent one that I want to talk to you about. It's this one here. And I'm going to do 2 things. I'm going to outline a bit about the project and the results, and then bring forward a reform proposal that has cropped up in the process of updating the project just this year. First, a bit of background, which is that the UN Guiding Principles on Business and Human Rights, which were endorsed by the UN Human Rights Council in 2011, established, I think most importantly, a new definition of what it means for a business to be responsible, to respect human rights. And that definition has been absent from the CSR debates for the last 2 decades. And it has now been globalized rather rapidly through the revisions of the OECD guidelines for multinational enterprises, which we heard about this morning, through the EU CSR strategy, which was also revised to become coherent with the UN Guiding Principles, through the IFC instruments, we heard the performance standards, and through market mechanisms like revisions of the ISO standards on CSR. And they continue to be influential in defining ways that business can respect human rights. So with that in the background, a coalition of, or I should say a coalition of coalitions, a group of coalitions, the International Corporate Accountability Roundtable based in Washington, the Canadian version and the European version, got together and asked the question, well, if the UN Guiding Principles has defined what it means for a business to respect human rights, and at the same time have reaffirmed what it means for states to protect human rights as the first pillar of the principles. How do these 2 things connect? Well, the second pillar, this one that I've been talking about, the responsibility to respect by human rights, by a business, basically places due diligence at the center of the operational notion of what it means for a business to respect human rights. And so what we set out to do was to ask the question, do states use due diligence to encourage or require businesses to respect other standards? If they do so, how do they do so? What are the compliance strategies, and in particular, how might national legislators use new or existing law to encourage or require human rights due diligence? So we set up a group of experts. I was one, Professor Anita Ramasastry was another, Professor Olivier de Schutter was another, and Robert Thompson was the 4th. And we held 5 regional consultations with scholars and practitioners from around the world. This was during the course of 2012. And we asked them for examples of due diligence in legislation or regulation or different rules in their home countries. And the results were beyond anything we had expected from the start. We expected to find a lot. But we didn't expect to find so much. And we found about 100 examples in about 20 different countries across civil and common law jurisdictions, all regions and all levels of development, countries from all different regions with all different levels of development. We found it in criminal law, in civil law, in administrative law. And so we concluded that, well, due diligence does seem to be commonly used to regulate business behavior. but it is dispersed across different legal regimes within all of those different jurisdictions. So it's not something that is generalized with respect to business respect. And so it is used to protect against different commercial and public interests. I'll talk about that in a second. But it is very, very rarely explicitly used for human rights. So there's lots of due diligence in domestic law, but there's not very much due diligence that's specifically linked to the words human rights. The organizations helpfully put all of the examples up on the web, so this is where you can find them, with various search terms. What you'll find when you click on them is a summary of the rule or the law in question, and with a reference, so you can go to read the original. I must say that our audience was not legal scholars. The attempt was to provoke you, actually, into proving us wrong. But the audience was very much civil society. That was the constituency that had requested the project. And so we didn't just put the statutes up, we put summaries of the statutes up. But we do want to encourage legal scholars to engage, and that's why we put these up there, is to encourage the debates around due diligence. And while I said that they were dispersed across different legal regimes in these different countries, I think it is fair, what we said in the report is that you can identify, I think, 4 categories of approaches to the way due diligence is used to encourage or require business to respect a standard set in law. And I'll just very briefly go through those. One is as a binding obligation, either as a statutory requirement or as a form of defense. And I think all of you will probably immediately come up with different examples of this, but I'll just give you a couple. One is in anti-corruption law, anti-bribery law, both in the United States and in other countries. You see different ways that this operates. In the UK, the more recent UK Anti-Bribery Act, you have a specific requirement for due diligence spelled out in the law. It's a kind of what I would call a kind of strict liability standard with a due diligence defense. In the US, under the Foreign Corrupt Practices Act, it operates differently. You have sentencing guidelines that permit prosecutors to engage with business to identify what the due diligence standards are. And that's a very well-established process. In the United States, there's also other due diligence standards in areas of environmental law, quite strong ones. So those are elements in which you see them both as a statutory requirement and as a defense. We see it in Canadian labor law, for example, in workplace health and safety. The next broad category of approach is using due diligence as a condition for state support, and we heard a really good explanation of this from Camille earlier, where the Norwegian Export Credit Agency uses due diligence as the basis, as a requirement or a condition for receiving insurance from that agency. The third was through disclosure mechanisms, so disclosing the nature of the due diligence. I think it was mentioned earlier today, the Dodd-Frank Wall Street Reform Act provision 1502, which requires companies sourcing minerals from DR Congo to report on their use of conflict minerals. And then the fourth broad area is a combination of these different approaches. So you might receive a license for a particular operation on the basis of an environmental impact assessment, for example, and failure to meet certain standards under the same legal regime might be enforced through criminal prosecution for environmental crimes or civil actions on the part of citizens. I think in general, in all of these cases, there was a dual function for due diligence. So on the one hand, it is a performance standard. It communicates to business what is expected behavior in practice in order to meet a standard set in law, and it's used at the same time by regulators to assess compliance. And this is actually quite important within the field of business and human rights, where both of those issues, in other words, what a business is supposed to do to respect human rights and how governments might require them to do so, have been contested for a number of years. Okay, I have 1 minute left, so I'm just going to very briefly throw out an example, or I should say a reform proposal, because it's not mine. But two French organizations worked with members of the Assemblée Nationale in France to develop something, and it was just been released, as you can see, or just introduced, I should say, to the Assemblée Nationale in November of this year. And it basically proposes to revise the penal and civil and commercial codes to require businesses to conduct due diligence. It would amend the French Commercial Code to require companies to monitor activities they undertake that might violate fundamental rights, including through subsidiaries and supply chains, and implement measures adjusted to their potential impacts. And it would allow for civil and criminal liability to arise from infringements of those rights, both at home and abroad. An extremely interesting proposal, one that I put forward here because I think 2 years ago in the field in which I work, this would have been unthinkable. So even though it may not appear to be radical, as I say, in the world in which I work, it's an extremely interesting step that it has actually moved to the point of being a proposal in law. I think I'll stop there in the interest of time. Thank you.